In this video, we are going to evaluate the meaning of the red light, green light, and right-based theories from administrative law and discuss which theories is the most relevant theories based on recent worldwide events of 2020. Before evaluating these theories, I will first explain what administrative law is. Administrative law, also commonly referred to as public law, is the body of law that regulates the function of administrative agencies which comprise the legislation, adjudication, and implementation of public policy. It could simply say that the nature of administrative law is to govern the power of the administrative authorities against their abuse and to grant the remedies to the aggrieved citizen. Besides regulating the relations between different parties and the power in which administrative authorities exercise, the purpose of administrative law are identified and underlined by Pierre Lalande and Thierry Roux. According to these two philosophers, administrative law aims at facilitating good administration by implementing rules conducive to good administration, commanding public institutions to fulfill their legal obligations, and supplying accountability and transparency to their actions. So now, what is red light theory? Red light theory is one of the principles laid out by Harlow and Rowling and was described as a model of law's approach to administrative law. This theory aims to protect the individuals by curbing the state activities. It is the approach that advocates the centrality of the courts in Constitution, which with significant power to review administrative decisions and regulate any excess state power. An example of the theory can be shown in the ruling of the courts in the case of NS Limited and Foreign Compensation Commission, where the case illustrated that the courts will not be deprived of jurisdiction in judicial review unless in certain circumstances. Simply saying, it is a theory that tends to control the excess power of the state and subject it to legal and more particularly to judicial control to minimize the invasion of individual rights. Based on the red light theory, the theorists believe that the law outweighs politics. For example, when there are different programs created for different sectors of a state such as transportation system colleagues and education system member, the law should be emphasized over politics. Besides, they also believe that the administrative state is something that should be kept under regulation by law, and it is the preferred way of doing this through rule-based adjudication in court. Furthermore, theorists further believe that the target of the public law project should be subjected to the enhancement of individual liberty. Therefore, the judicial notion of administrative justice, which compels the executive to maintain power within their legal scope to protect individual rights, was mirrored in this theory. In addition, this theory was also exposed by Lord Diplock in Council of Civil Service Union and Minister for the Civil Service, declassifying the existing basis of judicial review that earlier emanated in Wednesbury Unreasonable case. Hence, illegality, irrationality, and procedural improbability could thus be considered as the basis for judicial review of an administrative action.
Hi, I am Anchi, and I will continue to talk about the green light and red light theories, which are applied in the UK administrative law. Apart from the red light theory as mentioned by my teammate Jia Xuan, green light theory was also introduced by Harlow and Rawlings as one of their famous metaphors. The green light theory originated during the World War as an alternative approach in administrative law. This theory emphasized on freedom given to the government to exercise their statutory roles as well as powers vested by statutes or delegated legislations in the decision-making process. In contrast, the red light theory highlighted the importance of judicial control by way of judicial review toward the executive to prevent misuse of powers, which can be done by way of ultra vires, improper use of power, and failure to take into account relevant considerations. However, noted that the green light theory does not promote exercise of arbitrary and unrestricted power, but merely favors regulatory measures. In short, the focus of this theory shifted from underlining the judicial control to emphasizing political process. The main objective of green light theory is to minimize the intervention of the court to executive actions. In that sense, ministers or public authorities who were authorized the power to adjudicate on state matters are required to make appropriate decisions as well as to be accountable to the consequences of their actions. The court in this case will exert less control upon the executive actions. This is because the principle of administrative law is not to cease wrongful action, but to facilitate the operation of governmental action. Thereby, the court should not be too interventionist towards the administrative actions, as the absence of interference from the court enhances the efficiency of governing process. Consequently, this implementation seeks to preserve the rule of separation of powers as expounded in the case of R and HM Treasury ex parte Smedley. The significance of this case is that separation of powers was emphasized by the courts. It was said that separation of powers between the executive, judiciary, and legislature is constitutionally significant. However, the supremacy of Parliament over the other two institutions should be withheld at all times. According to C.K. Thakmani, both theories aforementioned have their own pros and cons. Thereby, there were theorists who are inclined toward a distinct theory called the amber light theory, which lies between the two theories called green light and red light theories. It is a flexible approach which does not cite any of the two extremes. It suggests that the approach to be used differs in each situation. Therefore, the merits and demerits of green and red light theories should be assessed in order to strike a balance between the conflicting viewpoints of the traffic light analogy. And now, my teammate will continue to talk about the right space theory. Thank you.
Hi, my name is Yi Ying and now I'm going to talk about the right space theory. In fact, administrative law has significant importance in supporting rule of law and fundamental rights. It has resulted in the appearance of a right space theory. A clear distinction between positive and negative rights has also been drawn. Negative rights are those rights that others cannot interfere with you, while positive rights are those rights that others must help you in some way. In regards to right space theory, Sir John Lawes had emphasized the function of court in numbers of articles, and he contended that the court should play a role as the guardian of essential common law rights. In light of that, the judges have obligation to establish the validity of the decision made by executive or other public administrators and to safeguard the citizens' rights. Therefore, the laws that cease the judiciary from doing so are conflicting with the doctrine of rule of law. Apart from that, regarding Sir John Lawes' rights-based approach in judicial review cases, if the public authority had put substantial intervention on citizens whose rights are at stake, then the authority must provide strong reasons for the action. The concept of common law constitutionalism might be claimed to show most of the elements of classic rights-based constitutionalism and also invoke the idea of individualism. The fundamental rights being ascertained in such a way are considered as making a higher order of law which also binds the parliament. Giving protection to those fundamental rights stated within statutes would ensure to uphold the rule of law. The concept of rule of law comprises the components of certainty, liberty, as well as equity. Under this concept, it could be said that no man is above the law. Thus, if a public authority acts beyond the legislation and violates someone's right by an irrational or unlawful decision, it requires to be resolved by the method of judicial review. Obviously, the fundamental rights are always being protected by the courts. The Human Rights Act 1998 has significant effect on judicial review because the citizens would rely on its provision if their rights had been infringed. Before Human Rights Act 1998, in Rex and Ministry of Defense ex parte Smith, the court held that if there was any interference with human rights, the court would ask for a greater justification. After Human Rights Act 1998, Chief Justice Mark Fernando expressed his view that the jurisdiction of executive should be subjected to the protection of human basic rights in Heather and Leonard Cheshire Foundation. Moreover, Isamaru as Secretary of State for the Home Department case, even though the case was judged using different legal structure, it had demonstrated the court's dedication to protect fundamental rights. Lord Steyn also elaborated that the courts must presume the laws are designed to be subjected to the human fundamental rights if there are no unambiguous words contrary to it. It is clearly shown that the rights-based theory is an important feature of administrative law. Thank you.
Hello, my name is Zarina, and I would like to talk about the events that has happened in 2020. We're 5 months into 2020, and it's already a hectic year. However, one event that caught my attention is the event of Brexit finally taking place. On the 31st of January 2020, the United Kingdom officially withdrew from the European Union, which is well known as Brexit, after constantly receiving votes from the British Parliament to delay the withdrawal. However, in September 2019, the Prime Minister of UK, Boris Johnson, refused to delay Brexit for the third time, even when the Parliament passed the law to delay the UK's exit from the European Union. This action gave Boris Johnson a risk to be impeached by the Parliament and subsequently removed from the office. Based on the situation that unveils itself, the red light theory can be applied. Impeachment can be defined as a method taken by the Parliament of the United Kingdom to prosecute and put individuals on trial for high treason that is usually beyond the reach of the law or normal prosecutions.
Here's the keynote before we move on. First, we have this where the member of House of Commons have proof of individual's crime, and the individual is usually power of authority. Since they have the proof of the said individual's crime, they have the chance to charge said individual. So if the other members of House of Commons were told about this, they will immediately vote for impeachment. Once they get the majority to vote said individual for impeachment, the said individual, which is known as the defendant, will be sent to the courts of House of Lords in the name of House of Commons and all Commons of UK. Once the case is brought to the House of Lords, the House of Commons will choose a committee to create an article of impeachment, and the article of impeachment will be sorted by each charges the said individual have. And then once everything is done, the House of Lords will bring the defendant into custody and they will set a date for the trial, while at the same time, the House of Commons will choose a manager to be a prosecutor for the case. Once all of this is sorted through, the trial starts. Once the hearing ends, the members of the House of Lords will vote on simple majority on each charges. And once the judges of the House of Lords call for the verdict of each charges, the peer must rise and declare either guilty or not guilty upon my honor for each of the charges. The House of Lords will decide if the defendant is guilty or not. If the defendant is guilty, the House of Commons will move for judgment on the defendant, and once that happens, only then the House of Lords will decide on punishments, and the said punishment must be within the law.
This issue came to light when Boris refused to delay Brexit until the 31st of January 2020, even after the government did not get parliamentary approval for leaving the EU without a deal, as per that Act. Boris's refusal to write a letter of delay can be considered going above the law, which infuriates red light theorists because they believe in strong judicial control over the executive power, thus preventing the authority, specifically in the executive, from going out of control. Because of this, it is said that red light theorists believe in intervening the judicial review at full force in the reason of arbitrary power control and the promotion of the rule of law. At the end of the ordeal, Boris Johnson and the European Council eventually came to a conclusion to delay Brexit for the third time. Thus, impeachment was not carried out by the Parliament. However, if Boris Johnson were to stick to his words, impeachment would still not take place. Why, we may ask? It is still two reasons. One being inactivity of the process since the impeachment of Henry Dundas, first Viscount Melville, which was dated way back in 1805. Second reason being the nature of the impeachment as an out-of-fashion political weapon. Now that I have talked about one event, let us move to the next event, shall we?
Hello, my name is Sabina Eunice Stevenson. Another worldwide event is COVID-19, a worldwide pandemic that has been spreading since the end of 2019. The whole world has gone through process of locking down their countries, which forced people to stay home, employees become jobless, small businesses are closing down, and some economic sectors such as hotel and casinos risk permanently closing down as most countries are experiencing economic downfall, awaiting decisions. Stress are on the healthcare system. Each country should have the same goal, that is to protect the citizens by keeping citizens shut at home and risk economic downfall or loosening up the policies. During this time of emergency, the green light theory plays an important role. In this time of crisis, government need to make policies that are efficient, and justice for all citizens also need to be present. Courts' roles are to be restricted in order for these policies implemented to make sure good governance. In short, the majority power is on the state. This can be seen when British citizens were repatriated from the countries where the virus climaxed. British government straight away transported them to locations to be quarantined for 14 days, and this was a need to prevent the possibility of the virus spreading from them. However, the government had no legal standing to impose this, but only relied on legal consent that can be withdrawn by those in quarantine. The decision that a government has to make firstly is to delay the spread of the virus to their citizens. One way to do this is through limiting citizens' movement and moving on to locking down as this issue deteriorated. The government first announced that certain businesses should close. They had power under the Public Health Control of Disease Act 1984, which includes extensive but limited powers for the government to make regulation to protect health. On 21st of March 2020, the Secretary of State for Health and Social Care made emergency plan to sign the Health Protection Coronavirus Business Closure England Regulation 2020. This allowed people under both categories, domestic cases and overseas cases, to be detained for screening to ensure they do not risk infecting people. This shows that the power to detain in terms of isolation relied on the assessment of the public health consultant or the Secretary of State, and if in a case where the period need to exceed 14 days, the Secretary of State is to review these cases daily. Under Section 45B, it states regarding international travel, where a minister is given power to make decisions by regulations such as detention, medical examination, and isolation. Section 45D gives minister to make regulations and restrictions for the purpose of preventing and controlling the spread of this infection, and by this the lockdown was announced by the UK Prime Minister. Section 45G states regarding power to order health measures in relation to persons, and Section 45I gives power to minister to order health measures in relation to premises. This caused business and leisure category to be closed on the 23rd of March, while Section 45P speaks about the general provision about regulations. This instant forced closure was lawful. After the passing of Coronavirus Act 2020, additional power were given to the government as the Coronavirus Regulation on the basis of British citizens who was international travelers who did not consent to their quarantine could be lawfully forced to submit. This act gives power to allow continuing detention or other restriction. Failure of a person to comply with these restrictions without decent excuse is a crime and will be punished by a fine. Thus, we can see that during times of crisis in the country, the green light theory takes place to improve situations in the country, where government has powers to make regulation to exercise their statutory roles, and those powers are vested by the statutes or delegated legislation in the decision-making process. Thank you.
In a nutshell, there is no definite answer as to which is the best theory. Someone would prefer green light theory as it is more realistic and functional, but someone would opt for red light theory due to its formalism. Thus, the most suitable theory will depend on the circumstances of each situation. Nevertheless, interpretation of the court could be said is a must for the purpose of keeping check and balance for both theories. In this view, the best yardstick is that the court places less control within red light theory, but more control within green light theory. Even though the politics and democracy is highlighted in the green light theory, there should always be certain control present as well. Hereof, an amber light theory could be suggested. Last but not least, although both theories adopt different principles, we could still observe that both of them are likely to uphold the fundamental rights and support the rule of law in different positions. In short, the rights-based theory acts as an essential element throughout the whole administrative law. Thank you.
Thank you.